I am David Pierce. I'm at Coolidge Wall. I know you have heard at least one other speaker from my firm. In the past, we have been around since 1853 in one form or another. We are organized by departments. We have a corporate real estate, estate planning, and tax. And then the two departments I chair, which are litigation and labor and employment. Within my practice area, I do a lot of not only business work, but a lot of labor work. I am a certified expert in the area of employment law by the Ohio State Bar Association, and I spend a lot of my time counseling employers on various HR topics, including the topic for today, which is OSHA. I can't tell you it is a large part of our practice, but it is certainly something that we deal with on a regular basis. So I always start my presentations, I'm told, are always very interesting. So I try and have a little humor in them. I hope that's okay with everyone, even when we're talking about a serious topic like workplace safety. Please know that I'm just trying to lighten the mood. And you know, it's not all a good joke, right? So we start with a disclaimer, right? Not exactly the most humorous of topics, but it is important to understand that if you have questions, certainly I will stick around at the end. I'll entertain questions at the end. Ask them for a friend, right? Hypothetical questions, that's what we deal with in settings like this. In the rest of my life, I deal with personalized questions, client advice seeking questions. But for purposes of today, please ask them in the form of a hypothetical or in a general fashion. Okay, we start with OSHA. OSHA has been around since 1971. And at that point in time, what was going on in the world? Well, coincidentally, Charlie and the Chocolate Factory. So we have rivers of chocolate running through factories without any safety rails to grab a hold of, without any flotation devices to sit on. We have children walking around unsupervised in the factory who can get sucked up into the drain pipes of the world. We have the poor Oompa Loompas that are around working away. And coincidentally, at the same time, President Nixon and Congress put into place OSHA. And OSHA's mission at that time and today was to provide safe and healthy working conditions for employees, okay? And we're going to talk about how they do that as I go through my presentation today, the regulations that are in place, the enforcement mechanisms, citations, things like that, as well as your record-keeping requirements and the like. And we're also going to talk about some whistleblowing protections that come along with OSHA and how we handle those claims. OSHA is an organization that has a budget of about $600 million, and they have about 1,850 inspectors or employees between federal and their state partners. And what I would tell you is that sounds like a lot, and those sound like big numbers, but not when you're dealing with a workforce in the hundreds of millions of people like we have here in the US, right? I've seen estimates of between 111 and 150 million employees in the US. So it's impossible for any organization like OSHA and its state partners to go to every site on a regular basis. It would take years and years to do that. Has OSHA worked? That's a question that is often asked. OSHA would tell you, yes, of course. We've seen our fatalities drop from 38 per day in 1970 to 15 per day. And we've seen injuries and illnesses that get reported drop by 75% a day. Now, there may or may not be other reasons for that as we look at the changes in technology and the environment over time, but at least OSHA's position is that it works. For those of you that have not dealt with OSHA, OSHA is organized by regions. There are 10 regions throughout the US. We are in Region 5. which is actually the Chicago region here in the Miami Valley. There are more area offices. We have, I think, 83 area offices. The one that you would have to deal with if and when you have a citation in your workplace would be in Cincinnati. That's the closest office, okay? There are responsibilities that all employers have, and we're going to talk a little bit about rights and responsibilities. Responsibilities for employers are, of course, and these are, by the way, not best practices, these are the law, to provide a workplace free from recognized hazards and comply with OSHA standards, to not discriminate or retaliate against workers. There are certainly training requirements and record-keeping requirements and reporting requirements, all of which we're going to talk about today. Employees also have responsibilities. They have responsibilities to use PPE when it's provided to them, to report injuries, not to behave like the guys on my screen. If you have a workplace where you have people that are engaged in unsafe behavior, OSHA will actually look at that as part of the compliance, a compliance failure on the part of the employer, and there can be penalties. So if you see this kind of stupidity in your workplace, please make sure to put a stop to it. With responsibilities, there are rights. The employee rights are to have a safe and healthy workplace. They have rights to know about certain chemicals in the workplace, to get data sheets on those chemicals. They have the rights to report things to their employer and to be free from retaliation. Employers also have rights. And these are kind of due process rights, which I'm going to get into when we talk about injuries in the workplace. Right to be present during an inspection, to protect confidential information, to accompany the OSHA inspectors, and to appeal violations. Okay? So how do all these rights and responsibilities interplay with each other? Well, typically, when I get involved, when you get involved, is when an accident occurs, right? I want to talk about what to do when an accident occurs and sort of some best practices there. First and foremost, which you all know and would all do, I hope, is to provide appropriate medical and first aid care, right? If 911 needs to be called, please make sure to do so. Please make sure that the employee is taken care of. And I think everybody would intuitively do that. Once that has happened, we need to do an internal investigation. And an internal investigation, OSHA views, is an important part of or component of a safety and health system. It's one of the things they're going to look at. What is your process for handling accidents and incidents? So please make sure that you have a process in place. That process, of course, should be documenting how the accident happened, talking to witnesses, considering appropriate remedial measures, and things like that. What I see a lot of companies not do very well is make sure that they are preserving the scene, right? Make sure that not only are there photos taken, but there's not going to be any doubt if there is a lawsuit or an OSHA investigation or anything like that in the future, we need to make sure that we can show exactly what things looked like and what the conditions were at the time of the accident. If you don't, you might be accused of sort of destroying, or the legal term is spoliating, evidence or important information. And that might also involve having to put in place what we call litigation hold, which is to make sure that all documents, information, text messages, emails, anything having to do with the particular incident or accident are in fact preserved, okay? Then we're going to get into your reporting and your recording obligations with respect to the accident or the incident. And then you need to make sure that there is no retaliation of any kind against the employee involved. Let's talk about record keeping just for a few minutes. Record keeping is going to apply to you unless there are one of a few exceptions. You're going to have a record-keeping obligation unless you have fewer than 10 full-time equivalent employees, or if you're in a very low-risk industry, you may not have recording obligations. So how do you know? You can go on and you can look up your industry code on the NAICS. I could show you how to do that, and you can look and see what exactly your recording obligations are. Fortunately for us in the legal field, we are in one of those exempt industries that does not have record-keeping requirements. But generally speaking, unless you're in an environment where maybe you're self-employed or you're under 10 employees, you're going to have record-keeping obligations. So what do we have to record? Well, the first thing we have to look at is, was the accident or illness caused or contributed by something that took place in the workplace? And we also can get into substantial aggravation of a pre-existing condition. So those of you in the workers' comp arena are probably familiar with these concepts. I could spend a whole day talking to you about whether or not something really happened at the workplace or not. But that's one of the things we're looking at. Was it caused or contributed to in the workplace? And it has to meet one of these special conditions. Was there a death involved? Were there days away from work where an employee couldn't be at the facility or in a reduced capacity? Was there medication beyond first aid? And first aid is a defined legal term. Certainly cuts and things like that of a minor nature do not count as something that would have to be recorded. That would be normal first aid. And then assuming you have a recording obligation, you have to talk about where to record it. And in the private sector, that is on a OSHA 300 log typically. In the public sector, I think it's 300P is the acronym, but they go right along with each other. So you have a 300 log. That's your basic log, which indicates name of person, date of incident, what happened to the employee. You also have the summary log, which is the 300A log. Again, similar acronym in the public sector. And a 301 log, which is a more detailed injury log about what happened to the particular employee. The 301 log must usually be done within 7 days. And a lot of these records must be kept for a 5-year period of time. So something else to pay attention to is your record-keeping policies. Whether or not you have an obligation to record information, you probably do have a reporting obligation. And so what typically happens when I get called, it'll be, hey, we had an accident at the workplace today. This happened, just wanted you to be aware. And I say, okay, what happened to the employee? Well, it was a very minor fall. Okay, was he injured? Yeah. Did he go to the hospital? Yeah. Was he immediately released? Well, they kept him overnight. Well, we're gonna have to report that. And not only are we gonna have to report that, but we're gonna have to report that within 24 hours. And if it's a fatality, it's gonna have to be reported within 8 hours, okay? So very quick obligation to report certain types of injuries. Pay attention, of course, to amputations, inpatient hospitalizations, things of that nature. And when you report, there, of course, is going to be a visit by OSHA in a very short period of time, in all likelihood, if it's a serious incident. If it's a death, you can almost bet they're going to be there the next day. There are penalties for failure to report. A lot of this is common sense, but it's things that you guys already know, which is accidents happen. That's one thing. Trying to cover up an accident, failing to report the accident, that can subject you to some real penalties, and in some cases, even criminal conduct. That's where the problems happen. Okay, a lot of times I get this phone call. David, what do I do? OSHA is at my door. And I say, okay, well, before I tell you what to do, let me ask you a question. why is OSHA at your door, right? And the answer is typically, didn't I tell you we had that guy who was seriously injured here? Or I self-reported this. Okay, well, that would have been good to know because I could have promised you that OSHA was going to be at your door and we could have talked about what to do beforehand, okay? Again, if it's a fatality, they're gonna be there very quickly. And you better have a plan in place, a communications plan in place, something like that. And you should be planning for the same for a serious injury. So I was trying to figure out why are they there, right? What happened? Was there an injury? Is it an employee complaint situation? If an employee complained, then OSHA may come out and investigate. Is it part of a normal routine inspection of some kind that OSHA has? There are certain industries that are high risk, that are targeted for routine inspections, and there are certain equipment. Imagine a power press, for example. OSHA may decide that they're going to investigate all power presses and come out and make sure that they're all safe, something along those lines. So they have special emphasis programs, they have programmed inspections, they have other things. And depending on why they're there is going to tell me a lot about what to do, right? Which is the question that I'm being asked. What do I do with OSHA? I'm always going to say, did you get some identification from the person that's there and get their name? Did you ask why they're there, right? I'm always going to start by doing those things. I'm probably going to try and get out there myself. And if I can't, I'm at least going to participate by the phone. And then I'm going to try and again figure out really what it is that they're there for. If they're there because there's a special emphasis program on power presses, I want to make sure they see the power presses and not everything else in the facility. If they're there because an employee complained about the air quality, then I want to make sure that we're able to give them enough information to do sampling of the air without seeing perhaps other areas of the facility. Whatever OSHA sees when they come out, they're able to cite your business for. So you need to understand what they're there for and in terms of how to coordinate the response. Now, questions sometimes I get asked is, can they do this? Can they just come out and start walking around and taking a look at my facility? Well, probably. You can say, do you have probable cause? Do you have a search warrant? We can get legal with them. And we can demand a search warrant, and there is case law out there that they have to come up with a search warrant. And I've seen that happen before. If it does happen, you can bet that the search warrant is going to be broader than whatever you could negotiate with OSHA, which is what I typically try to do, is to negotiate the scope of the inspection and the visit out there. So a lot of times, even though you may have those legal rights, your best bet is not to exercise them. OSHA will always do what's called the steps of an investigation are going to be an opening conference, the actual investigation itself, and a closing conference. So it's important to have somebody who knows what they're doing at those steps. The opening conference step, again, we want to talk about the scope. Why are you here? What is it you want to see? And limit the visit to that scope. We want to talk about who is going to be walking around the facility, and we'll talk about that. We need to be cognizant of the fact that there might be some secret information that we have laying around, some trade secrets, some list of things that we don't want just anyone to see or to know about. So we need to often coordinate those things. We need to understand how many people they intend to interview and talk to and how many days this is going to go on so that you can get back to your business. And then we have to assume that there are going to be certain information and records that they're going to want to look at. Again, depending why they're there, they're going to review logs, your safety programs, your PPE program, and maybe your hazardous communication programs, okay? That's all in the opening conference. It's very important to lay out the scope of that and to agree with the inspector on the scope of that. Then there's going to be an actual inspection. And they're going to walk around. I've seen or heard of this situation happening where all of those things happen, we negotiate the scope, and then we say, now so-and-so is going to give you a tour of the facility. And so-and-so wasn't involved in those discussions and shows the whole facility to the inspector. Okay? Obviously not what you want to do. If you've negotiated the scope, you want to make sure that their inspector is seeing exactly what the scope entails and nothing broader, and is not left alone. If the inspector or compliance officer is taking pictures, then you want to make sure you are also taking pictures. If there are samples of the air or of some other of the water or something else, you want to split the sample and make sure that you get the sample as well, okay? And a lot of what I'm telling you is it's information that, of course, everybody wants to cooperate and we want to do what's right and what's legal, but you don't necessarily want to subject your business to additional liability, right? So that's what we're trying to do. You don't want to volunteer information. If they're asking questions about one press, you don't want to say, well, that's not the machine where people get injured. Where they really get injured is over here, right? And then you're going to have a whole different set of inspections. So yes, you need to be honest. Of course, I would want you all to be honest, but you don't need to volunteer information. And OSHA may want to talk to what they call a competent person. A legal term kind of like a reasonable man, right? A competent person is typically someone who might be a bit of an expert in a particular area at your facility. Maybe it's asbestos, maybe it's something else that they will want to talk to. All of that's taking place during the actual inspection itself, and then you get to the closing conference, okay? The closing conference can be a telephone conversation. Hey, this is James from OSHA. Just wanted to tell you, David, what I found when I was out at your clients the other day. Or it can be an in-person meeting. Sometimes the compliance officers will tell you what it is that they intend to do. We're going to find the following violations, just these 2 violations. Best practices, not to argue, not to admit either in that situation, just to listen to what it is you're being told and then to talk to your attorney or advisors about that. I've also had compliance officers tell me, all good, no citation coming from me, and then in the mail, a week later comes a citation. So it is also possible that they have bosses and they get overruled on whatever their initial inclinations are as well. Okay, let's talk about citations. This works slightly different in the public sector than the private sector, of course. In the public sector, you're more likely going to be penalized for failure to comply rather than actually fined monetarily by an OSHA inspector. In the private sector, there are 4 categories of citations. Serious, other than serious, repeat, and willful. And then there's also a failure to abate or correct, okay? Those citations can carry substantial penalties, the worst being willful and repeat, which can, and the penalties get indexed to inflation. They can be up to $165,514 as of January this year per violation in the private sector. A normal serious violation or an other than serious violation can be $16,550 per violation for everything that's observed. So again, you'll typically get these citations in the mail. They'll describe the violation. It's not going to be pages and pages. It may be one, maybe a paragraph. It may be a cite to a federal regulation, 29 CFR or something or other. And then there's going to be one of those words assigned to it. Serious, which means substantial probability of death or serious harm could result from a condition other than serious, which I think of more like your, it's more like instead of having a speeding ticket, you have a tail light out, right? When you get the other than serious violation, equipment failure type thing. Not going to involve that likelihood of bodily harm. Willful and repeat again are very serious, to use that word, conditions which can cause a problem. Again, if you fail to abate, if you lie to the inspector, those can cause additional problems. So not uncommon if OSHA comes out, they're going to give you a citation of some kind. And then I just want to run through briefly what happens with those citations. You can, of course, pay it, or you can exercise your rights. Remember, I talked about the employer's rights. And typically, one of two things would happen in this scenario. The most common thing that would happen is that you would meet with the area director. I go down with clients to Cincinnati. I've also done these on Teams or some video platform, and you explain why it is you think the citation is in error to the area director. You perhaps can gain an understanding as to where they're coming from, but you can use it like if you want to think of it as a plea bargain type arrangement, right? Maybe I had a serious violation which I can negotiate to an other than serious violation. Or maybe I had a fine. We had one of these a couple weeks ago in my office, fine of $30,000 or $40,000, which was reduced to $5,000, okay? Just by virtue of saying the right things to the area director, proving that we had programs in place designed to prevent something like what occurred, okay? So that has to take place quickly, within 15 working days from the citation. At the same time, basically your appeal time is running. You have that same 15 working day period of time in which to file what we call a notice of contest and to appeal that violation. And the way that goes down, there is a Occupational Safety and Health Review Commission, which is independent, believe it or not, from OSHA itself. They will typically assign an administrative law judge to handle the appeal of a citation. And from there, there's other processes that take place. And depending on how severe the penalty is, if it's less than $30,000 or what's at issue, you may be able to do this on an expedited basis and get your hearing before the administrative law judge. If it is a substantial penalty, then you may have to go through sort of what you're used to seeing as a full-blown legal process, okay? At many times in this process, the administrative law judge may try and settle or resolve the case, so don't assume just because you didn't settle it at that informal conference I told you about that it can't be settled. From there, you go through a full-blown appeal to the commission and then ultimately into court if in fact it goes that route. Let's talk about something else. This is another whole part of OSHA is retaliation. OSHA has separate investigators in their whistleblower unit whose job it is to investigate for retaliation. And you might be thinking that the retaliation is only for workplace violations, but I'm here to tell you that the number of laws that OSHA retaliation kicks in on is maybe 20, and it includes things like money laundering and antitrust and other things which are protected from retaliation. Typically what happens, employee though complains of safety violation, most extreme situation terminated shortly thereafter. If the employee complains within a 30-day period of time, OSHA will investigate for retaliation. And it doesn't have to be a termination of employment. It can just simply be discipline. It can be reassignment. It can be a threat of something happening to the employee that can trigger their retaliation rights. And if in fact those retaliation investigations occur, then you're going to have to prove as an employer that there was some other reason why the employee was terminated or disciplined or whatever the case might be. So this is very similar to a lot of what I do in the discrimination world, where discrimination claims are filed and the employer has to prove that there was a legitimate reason for their actions and that it was not a pretext for discrimination. Lots of these retaliation claims, sometimes I'll have a defense of, well, that's great, but we never really knew who the employee was who complained about the water out here a couple of months ago, so there certainly couldn't have been any retaliation for that. Or there was no violation, or yes, but the employee was caught stealing from the cash register, so it's not for retaliatory reasons. But be mindful of retaliation because it can give you a problem. Okay, I want to talk for a few minutes about some of the latest and greatest in the OSHA world. And one, it will be a proposal to eliminate OSHA, 2, heat shield, and 3, the union walkaround. So let's start with the proposal to eliminate OSHA. This has been put forth by Representative Andy Biggs, who I think is in Arizona and is maybe running for governor of Arizona. And Representative Biggs has proposed the Nullify Occupational Safety and Health Bill, known as NOSHA, right, instead of OSHA. And it is a whopping, I think, 1 sentence long, and it pretty much says all those things that OSHA says are hereby repealed. That's pretty much what the legislation says. So certainly we are in an era of government deregulation, and that is an extreme version of what is being proposed. Do I really think that is what's going to happen? Do I need to play my Schoolhouse Rock jingle, or do you guys know what's coming, right? It's just a bill. It's just sitting there on Capitol Hill. It's probably not likely going to happen. But do I expect that the OSHA budget is going to be slashed? Do I expect that the number of OSHA employees is going to drop? Do I expect some of the regulations that have been proposed to be cut back? I think some of those might be very possible to happen, right? That is the era that we're in. Moving on to the heat injury and illness prevention standard. Are you guys all tuned into this? This is the big proposal about a year and a half, 2 years ago. We're going to require all of these environments in which the temperatures get above 80 degrees to have a heat injury and illness prevention plan. And it gets stricter when it reaches 90 degrees. And this applies both to inside and outside conditions, okay? And there's going to be, you're going to have assessments and audits, monitor temperatures. Obviously, if it's an outside environment, we're talking about things like shade and water and breaks and things like that, okay, is what the proposal is. That proposal sort of paused for a while. When the Trump administration took over, there was public hearings that took place, and then there were comments, and I think there were like 50,000 comments after the public hearings last summer, in which most employers and the chambers of commerce thought that this was too broad, that this one size fits all, you must have this program and plan in place was just too broad. We do not yet have the final ruling and regulation on this particular topic from OSHA. So it's not, I guess you could think of it as just a bill or regulation, but it is kind of not in its final form. Does that mean you shouldn't be doing these things? Of course not. In both OSHA and the state equivalent for public sector employees, which comes under the BWC purview, both of those organizations could cite your business under their so-called general duty regulations. The general duty clause provides that all workplaces must be free from recognized hazards likely to cause serious harm or death. That can be the grounds for a separate OSHA violation, and there have been a few cases that I'm aware of in which OSHA is citing heat injury and illness violations under the general duty clause while this regulation waits to take effect. Another big area that I want to just talk about briefly is going back to this OSHA walk-around or inspection. What's happened is OSHA has broadened who can participate in the walk-arounds by their regulations. So it used to be that the employer could have their lawyer like me, or they could have a safety professional or somebody walking around with the inspector, but the employee could only go by his or herself. Now OSHA has broadened that to include third parties. And the third parties significantly can include union reps or business agents. They can include safety professionals or hygienists if in fact there can be a claim that it's reasonably necessary for a thorough investigation. And that really brings fear in a lot of employers that we don't know who's going to be walking around. We don't know what they're going to see. We don't know if they're going to be seeing, again, if we go back to confidential information or trade secrets, are they going to see those things? And employers are just sometimes not wild about people who don't belong in their business walking around their business, right? So, but that is in fact the rule that we're dealing with at the present time. Frankly, I haven't had too many problems with that rule, but that is in effect at the present time. Okay, I was going to talk to you about government shutdowns when I was asked to speak, but fortunately I don't have to talk about that at the moment. That was another thing that we dealt with OSHA. As you might imagine, your obligations don't stop during a government shutdown, and if something really serious happens, there would still be people there, but there were a number of other services that were curtailed during the government shutdown. Again, if you're a public sector employee, much of what I just talked about applies to you under the auspices of the BWC. There's a program there that's called the PERP program that applies to you, and the standards are mostly the same throughout. The record-keeping obligations, reporting obligations, very similar across the board. But please, I know, again, I've tried to make a few jokes. This is obviously a very serious topic, and please make sure that your workplaces are up to date on all of their safety practices so that we're doing what we can to prevent accidents and injuries.